friends and family, colleagues and agents alike. Thank you very much for joining us this morning. We've got an absolutely full house, which is really, really great to see, and we really, really appreciate it. So a huge warm welcome from STBB from our side in Cape Town. And we've also got Anastasia, Vanessa, Armand, I see, is joining us from our Johannesburg branches. So a very, very warm welcome to everyone. Guys, today we are going to be chatting to you about the impact of coronavirus, or more specifically, the impact that the lockdown as a result of coronavirus has had on our contracts in the property game. So whether that's your OTP contracts or whether that's your lease agreements, we will, during the course of our presentations, be covering these topics for you. So just to let you know, this is part one of a three-part series that we will be presenting to our Johannesburg clients and friends and colleagues. So this morning's discussion is going to be led by my colleague, Liezl Solomon. She is a senior associate in our conveyancing department in Cape Town. My name is David Thompson. I will be handling some of the other questions regarding Vis Major. I'm a director at the litigation department in Cape Town. So this morning's discussion, we're going to focus on the impact of COVID-19 on your offers to purchase specifically. So with regards to, sales and new offers that you're taking during this period. The second part of our discussion, which will hopefully be this time next week, will be focusing on the impact of COVID-19 on lease agreements. And then the third session that we'll have the following week, hopefully, will be an open Q&A session, which will basically just be an open forum where we can discuss openly, questions and hopefully give you the answers to those questions that you might need to have. Okay, guys, so with that in mind, I will invite Liezl to introduce herself and then get started. Liezl?
Okay, I'm going to share a screen with you guys just to keep the flow of the training going. So you guys could have a look at this and we'll take it from there. So just briefly, and I'm sure you guys all know, so don't hate me for repeating this, but obviously the impact of the lockdown on our property transfers and registrations, together with mortgage bonds and the like. Things that have happened since the lockdown or from the lockdown was that our deeds registry is completely closed, despite a few petitions that the deeds registry be declared an essential service. There has been no answer on that. I actually checked yesterday. So our deeds registry is closed, which means we have no registrations and no new lodgements going into our deeds office, which gives a month's delay minimum to any transaction that you're currently busy with, so any of your deals. Together with that, SARS and the municipalities are also working on skeleton staff, and transfer duty receipts, transfer duty exemptions, and rates clearance figures have not been prioritized. So we've got a delay on that side as well. If any of you are developer agents, your developer clients obviously also have a standstill when it comes to construction and development, so there'll be a delay on that. So none of what I've mentioned now is good news for any of us, but we're going to try and make it possible for us to see a bright side through this, and just to help you guys manage existing deals, and also if you're busy contracting and busy negotiating, how you can enter into deals during the lockdown. I mean, we're all at home, we have all the time in the world, and we've got technology. So yeah, there is a way that we can look at the positive in this and sort of manage it from that point. So we're going to start just to discuss the contractual obligations and contracts in general before we get to specific clauses and suspensive conditions in your agreements that might not be met during this time. So I'm going to ask David just to have a chat with us quickly on Vis Major clauses that may be in your offers to purchase, and in the absence thereof, supervening impossibility and who bears the burden of proof in those scenarios. So David, will you enlighten us on those topics?
Sure. Thanks, Liezl. Guys, basically, you would have heard a lot of people talking about impossibility of performance and force majeure, acts of God. These kinds of terms are being thrown around quite loosely at the moment. But what does it actually mean? So I'm going to just briefly touch on what these concepts or what these terms mean in a contractual setting. Please forgive me if you've heard this already, but I think that it is something that we need to keep in mind and constantly keep sort of in the forefront of our minds when dealing with contracts. And as you know, any offer to purchase or any lease is in fact a contract. And these kinds of terms that have been thrown around will obviously have an impact on how these contracts play out. So just from a general perspective, people talking about vis maior and acts of God and impossibilities of performance, what does that actually mean from a contractual perspective? Right. If you enter into a contract with someone, there are reciprocal obligations in terms of that contract. I offer you something, you accept it, and you have to do something in return. Okay? Now, when something happens that is beyond our control or out of our control, and it's something that wasn't foreseen by the parties when entering into a contract, that is normally referred to as a vis maior. Okay? It's something that happens completely out of the blue that no one contracted for. Okay? And what can happen as a result of something like that coming about is that obviously it will affect the contractual obligations of each party and how they can reciprocate their respective obligations to each other. Now, if you find yourself in a situation where someone raises this, you have to ask yourself the question, or at least the question needs to be answered, is the performance objectively impossible to carry out? So as a contracting party, is it objectively impossible for me to do what I've contracted to do? And objective impossibility is a very, very, very difficult thing to prove. It's not to say that it's now become economically more difficult, or I can't really afford it, or it's now become, I've had second thoughts because of coronavirus or something like that. That's not objective impossibility, guys. And I think that's something that we really need to keep in mind when we are faced with these kinds of questions. An example of something that would be objectively impossible to do: if I purchase a house from you and that house burns down, or as a result of an earthquake, that house falls into the ground, it is objectively impossible for me to pass transfer of that house because there is no house. So that is the degree to which objective impossibility is judged or is assessed. Okay. Now, with that comes something that you might have heard of called supervening impossibility. Now, supervening impossibility and objective impossibility have the same standard of test. Okay. So if someone says to you, I can't perform my contractual obligations because it's now subsequently, after I've entered into the contract, become impossible because of COVID-19 or because of the lockdown, then it needs to be objectively impossible. And it needs to be something that happened after you entered into the contract. It can't be something that's happened before you entered into the contract. And what that means for a contract is that if something becomes superveningly objectively impossible to do, it should in theory result in the contract coming to an end. But as Liezl will show you now, there are various mechanisms that you can put into place to save a contract. It doesn't necessarily have to come to an end. So just from that perspective, guys, and if you do have any questions, if I haven't been clear, please feel free to share that, to ask your questions. But basically what it boils down to is you have to answer the question, is it objectively impossible to carry out those obligations? Liezl, I don't know if you want to add to anything there.
Yeah, I think it's just that we all need to acknowledge that the effect of the lockdown, we need to evaluate each offer on a case-to-case basis. So now that we have a general idea of impossibility to perform and how that will affect your offers to purchase, and whether the lockdown directly affects the performance, and if it's absolutely impossible or just temporarily impossible, in which we'll discuss what you can do to sort of negotiate, to sort of extend conditions in your agreements. I think it's a good time, and we'll do well to remember in this time that we can renegotiate and rearrange obligations relatively freely as long as all parties agree to it and we have it in writing and it's signed, and that all parties need to act in good faith at this point. I mean, it's not just one person in this position, it's a global pandemic. And that's what we from STBB have been encouraging our clients and our agent clients to consider, and to really just keep in mind that everyone's in the same position. So you can't be sort of hardballing a situation when your neighbor's sitting in the same position you are. So that's on my side.
And Liezl, if I can just add to that as well, examples of situations that you might find is where someone was supposed to take occupation of a premises on the 1st of April, for example. Now, objectively speaking, it would have been impossible for someone to take occupation on the 1st of April because of the lockdown. Now, that would have been an objective impossibility. But because the lockdown is not a permanent restriction, there are some instances, as Liezl mentioned, where you might be able to treat it as a temporary impossibility as opposed to an absolute possibility that brings a contract to an end. So there is also that distinction. So you don't need to get too worried about situations like that. There are instances where you can save a contract. Liezl?
Yeah, so I'm gonna go through a few scenarios with you guys. If you guys have any other scenarios, you'll just pop them in the chat and we'll discuss them. But the basic sort of suspensive conditions or clauses in an agreement that you'll find. So I'm just going to roughly go through one or two that we've had that some of our clients have sent on to us that we can just suggest to you guys. We'll get on the signing of addendums and signing of offers to purchase in a bit. But just from an addendum perspective, if you do have obligations that need to or have to have already been met in this time, it's a temporary impossibility. So your agreement wouldn't lapse because it's temporary impossible to take occupation or whichever scenario you have, just to save your deals and to keep your OTPs intact. And just for general understanding for all parties, that there's no confusion once the lockdown is lifted. From our side, we've gone through all our offers, all our deals we're working with in the office, and we've contacted the parties and we've entered into addendums. Just to set the record straight, that there's no confusion on your contractual obligations and duties in terms of an offer to purchase. So where your date of registration, most of your deals make provision for as soon as possible after a certain date, or as soon as reasonably possible. If you are in a situation where you maybe have link transfers or there isn't a later date, like availability of a later date, and you've set it for the 1st of April or the 15th of April or the 29th of April, then I suggest from a conveyancing perspective, and you guys must chat to your conveyancers in Gauteng, to enter into an addendum, and I'm sure Anastasia has done it, where you just basically state that your date of registration, which would have been on the 15th of April, will now be as soon as reasonably possible in light of the lockdown that has been implemented as a result of COVID-19, taking into account the delays involved with your local municipality, with SARS, and with the deeds registry. So you aren't setting a new specific date because we could have an extension of the lockdown, but you are just making provision for the delay that is caused by the lockdown. And once the lockdown, which is the cause, is lifted, we can then proceed per normal. And then obviously once the lockdown's lifted, we're not going to be able to register on the 3rd of May. Yeah, it is the 3rd of May, it's Workers' Day, on the 3rd of May, because now we'll have to apply for fresh clearances for transfer duty receipts if we haven't received them, re-lodge if we have, or lodge if we haven't lodged yet. So we do need to take time into account. Time is very important. Where, like David discussed, where you have an occupation date, a set occupation date, and your client, due to the lockdown, could not take occupation, then you'll just extend it by saying your date of occupation will be on a certain date or will be as soon as reasonably possible after the lockdown has been lifted. So that's what we can consider there. Similar to payment of occupational rental. So if your occupational rental was due on a certain date, or which might not have coincided with your specific occupation date, so monthly in advance, you'll make provision for that in terms of your addendum as well. Then I think banks are working, and all our bond ladies are still working. We obviously just can't sign our clients up, meaning we can't issue guarantees. And where your OTP makes provision for a guarantee to be issued on a specific date, and this is if your client hasn't signed the documents and the bank won't issue a guarantee, we'll have to extend the date of the guarantee. So in this case, you'll just say your bond approval is due on X date, or your bond approval will be due 14 days after the lockdown has been lifted. And should it not have been obtained within this period, then the parties agree to extend the bond approval to a certain amount of time after the lockdown, and similar to guarantees. So if your guarantee was due in the past 3 weeks or in the next 2 weeks, you'll make a provision for a certain amount of time after the lockdown to give parties an opportunity to sign up with their conveyances and to get the necessary documents that they might not have been able to obtain in this time. Then as a general clause, if you guys just want to have a full-on addendum to sort of speak to every single suspensive condition, and this will send on to you guys, is just to say that should this offer in your addendum, this is for current deals and for deals you're entering into now. I would insert this clause into every single offer you're entering into now with your clients, is to say that should this offer contain any suspensive conditions to which a time period is fixed, which falls due during the lockdown period or such extended period as may be proclaimed in terms of the Disaster Management Act, then the time period for compliance for those conditions shall automatically be extended and shall only be required to be complied with within a certain amount of days after the lockdown period has been lifted. So we'll look at a reasonable time, 14 days, 21 days, etc. So that's a catch-all clause, which will speak to every single suspensive condition or every sort of duty in terms of your offer to purchase. And it really just, it will reduce the amount of work you have to do to continue entering into addendums during the lockdown should it be extended. And it just really relieves parties from any confusion or any claims of supervening impossibility or force majeure, and it really lifts the burden of proof on a party that could not meet their contractual obligations.
Liezl, will you be able to make that wording available to Vanessa?
100%. I think I have sent her the notes. So Vanessa, you can just distribute them after the training. But I think it's good that you do have it at a hand, or if you have clients that need to know what the wording is, just so you guys can just sort of circulate it, and always just give your conveyancer, your local conveyancer, a call if you've got a scenario that's a bit tricky and you don't know what to do or how to deal with it. Regarding lease agreements, we are going to discuss this next week, but you guys just also need to know that if you do have a lease in place, or you're entering into a lease and there are certain obligations that have to be met in terms of a lease, the same applies for leases. You can also enter into a lease agreement and insert the same terms to say that if there is any duties in terms of it, so an ingoing inspection or on termination of a lease, an outgoing inspection, you can enter into an addendum to say that any duties that need to be performed by the parties will be done after the lockdown is lifted. So what we're really trying to do here is mitigate any litigious disputes that might arise from contracts in general, and also just really to save your deals and to keep all parties informed, and just reduce any further delays that can be caused during the lockdown or because of the lockdown. So David and Wesley Graham will discuss this with you guys next week in a lot more detail, the lease agreements. So save your lease questions for then, but yeah, it's just something you need to think about in this time. Then I'm just quickly going to go over just some other sort of consequences that are incidental to this lockdown, is your levies and your bond payments. So a lot of banks have now issued debt relief to their clients. So bond payments have been put on hold from a few banks, which is great for our landlords and great for our homeowners who have bonds. However, we've had a lot of questions about sort of payment holidays when it comes to paying levies or paying homeowners association fees. Unfortunately, that's the discretion of your body corporate or your homeowners association, and that'll continue as per normal. I have heard of 1 or 2 body corporates that have given a sort of a small relief to their owners or the members of the body corporate, but that's on a case-to-case basis and something that your clients need to bring up with their trustees of their body corporate. All right, so I think from that, does anyone have any questions they want to pop into the chat? We haven't really had anyone say anything. So
Liezl, I've got a list of questions. Oh, I'm getting feedback from someone's computer. Can you remute everyone?
Yeah, I think I can. Hold on. I think everyone's muted except you.
Oh, okay.
Yeah.
Okay, that's better. There have been a couple of questions that I've been keeping track of. One of the questions that came up was regarding electronic signatures, which we're still going to get to. And the other question that came from Ahmed was to ask regarding cancellation due to impossibility of performance, if we could give examples of that. Liezl, you can correct me if I'm wrong, but in the setting of an offer to purchase, I think it will be very difficult for someone to escape a contract because of impossibility of performance. And remember, guys, as a general rule, the person who raises the impossibility of performance as a defense for not being able to perform, he or she will have the burden to prove that it's impossible. So if I'm the purchaser and I come to the seller and I say, it is objectively impossible for me to do what I've contracted to do, I then, as the purchaser, have to show, I have the burden to show that it is actually impossible. But because the lockdown, we hope, is a temporary measure, I'm of the view that in more instances than not, you're going to probably find that the courts will apply this as a temporary impossibility versus an absolute impossibility. And the distinction between the two, just for the sake of covering it, in case I didn't get it across, clearly enough when I spoke earlier, is that if something is objectively impossible, in order to rely on an objective absolute impossibility to escape a contract, it must mean that the obligation is forever impossible. The example I give, for example, the house that's burnt down or the house that's fallen into a crevice as a result of an earthquake. I will never be able to give you that house. I'll never be able to pass transfer of that house. Now, the difference between that kind of impossibility and the impossibility that we're facing at the moment is that hopefully the lockdown will be lifted soon. So the impossibility that you're facing, so in other words, for example, I can't give you vacant occupation. It's physically impossible. It's legally impossible. But come 1st of May, I can give you vacant occupation because I can move, you can move, we're all allowed to not move again. So there's a temporary aspect to the impossibility. So I'm not sure that in the setting of offers to purchase that you're going to find a lot of instances where someone can actually escape a contract because of an impossibility or an objective impossibility, because in theory, that impossibility will go away shortly. And it's in 2 weeks or 2.5 weeks. So I can't really think of examples at the moment where an offer to purchase will be terminated as a result of an absolute impossibility. But having said that, it's not to say that it won't. And each case will obviously have to be dealt with on its merits. Liezl, I don't know if you have anything to add there.
No, I 100% agree with you.
Okay. Do you want to carry on, and then I'll just make a note of the questions and we can deal with that at the end?
Yeah, I've gone through the questions briefly, and we've had a few on if your clients don't have printers and scanners and how you can go about signing addendums and signing new deals. So yeah. Guys, the Electronic Communications and Transactions Act, so ECTA, allows for signing of agreements electronically, but it excludes the sale of immovable property. So any sort of contract relating to the Alienation of Land Act is excluded from this. So we can't rely on electronic signatures for alienation of land. So in your offers to purchase, What we can do, and we'll discuss what your options are if you don't have a printer or a scanner, and I think we all do it sort of already in this way, is that you can send an offer to a purchaser, they can initial, sign, complete the details, scan it back to you, and you send it to your seller, and they do the same thing. That is a binding contract. Where your clients aren't in possession of scanners, which I think is the majority of our clients at the moment who don't work from home or don't have facilities at home, your situation is different. And this is, we've discussed this earlier in one of our trainings, and I don't know how, it's not legally enforceable, but I think given the situation that we're in, and that, I mean, no one in the world has been in a situation as a forced, state of disaster lockdown, that where parties have a common intention to enter into an agreement of sale, they can't scan and sign and send back, but they both do conclude and agree on the terms of the agreement that have been sent to them. They've acknowledged their obligations and their duties in terms of the agreement, and they've accepted any duties and liabilities in terms of an agreement. We can agree that there's a mutual intention and a common consensus between the parties that they want to enter into the agreement. And it's my opinion, David, you can differ with me, that if this is the situation, and I wouldn't say WhatsApp or SMS, let's try to keep it formal. I think Andre asked that question earlier, is via email. If parties acknowledge receipt of the contract, the terms and conditions thereof, and that they will sign the contract when the lockdown is lifted, when they're in a position to do that, but they bind themselves to the agreement. In my opinion, if this had to be taken to court after the fact, and even though it wasn't signed, I think in the current situation, and I mean, it needs to be disputed in court before we have a sort of conclusion on this, but I think that could be read as you binding yourself to a contract. But like I said, currently it's not legally enforceable, but it is an option that we can use for now. It doesn't give you a lot of security, but that's my view. I think, you might differ, Anastasia, you might have a different opinion. But this is just for offers to purchase. Your lease agreements are a bit different. So David, what is your opinion?
Yeah, thanks, Liezl. In South Africa, we have a general proposition that you can't contract to contract. You can't agree to agree later. The definition of an agreement is that all the essential terms of the agreement must be in place to constitute an agreement. And when it comes to signing offers to purchase, one of the formalities required is obviously a signature, and electronic signatures are at the moment not accepted. However, having said that, we are facing unique and difficult times. And I don't think that a court is going to look at a situation where someone, by way of an electronic signature, whether they alter the PDF, you can add in words on a PDF and you can just say electronically signed or hereby accepted. And you attach that to a covering email and you say, please find attached offer to purchase, which is hereby accepted. The absence of a signature under the prevailing circumstances, I think that the courts will relax that formality and allow for those contracts to be seen as binding contracts. Having said that, we don't know, guys, how the courts are going to treat these kinds of situations. These are unprecedented times. We don't have precedents in South Africa for a global lockdown or for a global pandemic in these modern times. So we don't know exactly how the courts are going to deal with these situations. We can only go on how we interpret the law and obviously practical solutions on how to resolve these things as and when they come up. So I hope that addresses that query on electronic signatures. I would highly advise against doing it via WhatsApp or SMS. In fact, I would say it's a no-go from our perspective at least. So really do try and avoid doing it like that. Email would be ideal. Couple of questions that came through. One was, so Odette and Stan, I hope we've addressed your question on electronic signatures. Another question that came through from Ahmed, and it was also another question, I think that was from Car and Duncan, regarding impossibility of performance in the scenario where the purchaser has had to take a salary cut. objectively speaking, guys, in my view, I don't think that it would result in an impossibility, because remember, like I said earlier, if it becomes more difficult to pay, or if it becomes economically more burdensome to pay or to perform, that's not an objective impossibility. But having said that, where I think it might come in, more than likely, and Liezl can confirm with if she agrees or not, is the bond application. So I think, as far as I'm aware, in terms of your bond applications, you have a duty to disclose any changed circumstances to the bank as and when those changes occur. Now, if your bond is based on your salary of 50,000 Rand a month, and you have to take a pay cut, and now your salary is 25,000 Rand a month, that will affect the criteria upon which the bank has granted you a bond. So there, the bank might revoke the bond approval. Liezl, do you have anything to say on that?
So we have received communication from most of the banks that the bank's not placing the duty on themselves to reassess clients who've already signed, so suspensive condition being met in that guarantees have been issued, we just haven't lodged, or the client has at least signed the bond documents. The banks are not placing any duty on themselves to reassess clients after the lockdown. I mean, that their work would just start all over again. So they've moved this duty over to clients to the attorneys to discuss it with the clients, that in the event that your employment conditions have changed or your financial conditions have changed, the client needs to go to the bank and discuss that with them. So otherwise, in the event that we've passed the signature of the clients, the bank's going to proceed as per normal, and you can't hold the bank, or your client can't hold the bank liable, for proceeding with registration of a bond in that instance. So it is definitely the mortgagor or the purchaser's duty to discuss the change in their circumstances, their financial circumstances, with the bank. And I'm sure banks would be understanding at this point, I mean, of anyone whose financial circumstances have changed, and you just can't meet the requirements of your loan repayments. So I think that was someone's question, if the banks will reassess. Yeah. So I think prior to signature, there will be a reassessment process, or just loans that have been approved, but no formal steps have been taken after that. But definitely placing a large part of that obligation, and that it's going to be quite tedious for banks, I think, is on the purchaser, on the mortgagor, to address it with their banks if they've received approval. So
yeah. And then, so yeah, it would once again, because the burden is on the person who's raising the impossibility. So, for example, in this instance, the purchaser. If the purchaser wants to say, "I've taken a salary cut, I can no longer afford to pay this." Remember, there's a fine distinction, guys. Affordability, on the one hand, is not going to result, in my view, at this point, is not going to result in an objective impossibility. But insofar as that might affect the bank's willingness to carry on with your bond, the purchaser needs to bring that to the bank's attention. And then the bank will make a decision as to whether or not that bond will continue to be granted or not. And if it isn't, then they will more than likely retract the approval. And then we'd have to assess it as a supervening impossibility in the contract. And you'll have to deal with it in that realm. There's another question here that's come through from Stephen Ellis. Stephen, yes, and Liezl can confirm with me. I believe that we are moving into the realm of electronic signatures for office to purchase. There is draft legislation in place that is going to be providing for that. Liezl, am I correct?
Yeah. So okay. For the entire conveyancing process, it might take a bit longer than we think, but there is communication on that. So it could be, I mean, given this lockdown, it could be sooner than we think, but definitely not, I'd say, in the next year or two, being South Africa. But we are, it is on the board. So
Liezl and David, sorry, thank you for unmuting me, and I don't want to. This is your discussion, but you did ask me, Liezl, what I thought about something. So I hope you don't mind if I just quickly pop in. There's just because I've also been speaking to this group as they're my agents, I do know what they're asking. So I just want to add two things with regard to not being binding if it's an electronic signature, I absolutely agree with you guys. And we have to understand that the contracts must be properly signed, you know, for them to be legally binding. Obviously, we do not want to lose any deals in this time period because somebody cannot sign the agreement. And the suggestions that you made, David, are obviously very, very good suggestions. But I do think every single agent needs to understand that, as always, there needs to be consensus with regard to every single clause in that contract. And there must therefore also be consensus with regard to the fact that somebody wasn't able to sign that agreement.
Yeah, sure.
And they must understand all the risks attached to that. We do not have precedents. As David said, the courts haven't guided us in this regard yet because this is a very unique situation. But all parties must understand, if they knowingly go ahead with a transaction where one or both of them haven't properly signed that agreement, they need to understand what the potential risks are if somebody is looking for an out at a later stage during that transaction. And then the second thing with regard to the bonds and the affordability of the bonds, I once again agree with what both of you said. I just want to put it out there. I think some of the agents may be aware, the bond originators are already aware. Standard Bank has come back and has advised bond attorneys that if a bond has been granted and a buyer at this stage raises the fact of unaffordability, that they now can't afford that bond, we as bond attorneys have to reclassify that bond. When we get an instruction, a bond instruction, we classify it as a retail bond or a development bond. They've now added an extra classification onto the system that says bond needs to be reassessed. I'm not exactly sure what the wording is, but that's what it comes down to. And as you said, Liezl, the responsibility is then put on us and the bond originator who helped the buyer to get that bond to reassess that buyer on behalf of that bank, get all the documentation again to the bank. So they actually suspend that bond, even though it's been granted, until a reassessment has been done. And that is obviously something that we as agents and bond originators need to understand and disclose to our seller. You know, we have no choice but to suspend that bond that has been granted because it needs to be reassessed.
Absolutely, yeah, thanks, Anastasia.
Only Standard Bank has done that for now. There is talk that FNB is going to make the same decision very soon. So obviously, as the days go by and as things change, we will keep our client base updated. But we're also just trying to work through this and understand all the new systems that they're putting in place. Thanks, guys.
Excellent. Thank you for that.
While we have Anastasia, and this is also something that I don't know the answer to, where banks have given payment holidays on bonds, what is the interest charged on that as per normal for the interest, or is there sort of a penalty interest if you aren't paying?
So I'm not sure about that, and I specifically did ask one of our bond originators to guide me through that process. I think as with most things, probably terms are going to differ. So I don't think there will be penalty or interest, but you would have to make it up within your 20-year loan term. Or you could make an application to extend that loan term.
Okay.
You know, but for now, we're not exactly sure. Carly's sitting here with me, and he's an expert on the bonds, and he's just confirmed. We don't know yet. There hasn't been a directive sent out in that regard.
Okay. Okay, great.
Thanks. And Anastasia, just to add on what you said there as well, just for everyone out there, if you do conclude a deal via using an electronic signature, guys, please, best practice, and just to avoid any debate or any dispute or any uncertainty, as soon as lockdown is over, or as soon as possible after lockdown is over, get the physical signatures done. Even though that there might be electronic signatures, get the physical signatures done. That just avoids disputes. there was a question regarding if someone refuses to sign an addendum. Who was it? Liezl. If someone refuses to do something, anything, in terms of what they're contractually obliged to do, they will in essence either be seen to be in breach of the contract, or they will be seen to be repudiating the contract. It would then be the responsibility of the seller to put them to terms, either by way of the breach clause or by way of the repudiation provisions. And like I said earlier, if the purchaser then wants to excuse himself from the contract, he would have to then show, he or she will have the burden to prove it is impossible for them to do what they are being asked to do. So that's the basis. That's the starting point, guys. Always start with the contract and your obligations in terms of the contract. Enforce your obligations in terms of the contract as far as possible, within reason. And then if someone wants to escape the contract or the provisions of the contract or their obligations in terms of the contract, they must raise impossibility as a defense, or they must raise or give a reason why they can't perform. So any failure to sign would be seen, in my view, as a breach. Liezl, do you agree?
So most offers to purchase set out the duties and liabilities of a seller and of a purchaser. And in that is that the parties agree, in terms of the offer to purchase, to sign any documents necessary to enable registration of the property into the name of the purchaser. So by refusing to sign an addendum in order to secure the deal and further extend conditions in terms of the deal, the party refusing that is then in breach of their duties in terms of the agreement itself. So you guys would probably, most of your offers to purchase would have that clause. If you have a party refusing, you refer them to that and say it's your contractual obligation to sign documents that are sort of securing the deal or extending terms. And if it is because of impossibility or a change of a financial situation, that is then on the party calling for that to prove, like David said. So no, they can't refuse outright.
Yeah. A question from Sir Zoom. I really hope it doesn't get to the point of where you have to pull out Zoom meetings between buyers and sellers to prove contractual terms. But I don't think that is going to necessarily result in a binding contract. But if you get to a point where you're having to pull out Zoom meetings, you're probably already in the throes of litigation. And that will probably be used as a factor in determining what the intention of the parties were. I don't think it's going to be an outright decisive factor. It will be a factor to consider, obviously depending on what's said in the meeting and how it's concluded. But, one of the fundamental formalities of an agreement for the sale of a property is that it must be in writing. Now, if it's not in writing and there isn't a signature, now you're trying to jump over two hurdles, which are fundamental to a contract. You're just making it harder and harder. So I wouldn't place too much reliance on that. But like I said, if you've reached that point, then you're far down the litigation track already. And I really hope that you don't have to take it that far.
So right. Just on that, what I'd like to say is that for using not just Zoom, but any form of a communication platform like Zoom or Google Hangouts or Skype or whatever. You guys are currently sitting at home, you've got listings, you've got clients who want to view properties and they can't. And we've had a lot of agents that say that, what about the footsteps clause? What about in the similar with lease with ingoing inspections or having just clients view properties? I think it's a very exciting time in that the way we are working at the moment is things are going to change forever after this lockdown. People have realized how convenient it is to, guys, I'm going to tell you now, I'm sitting in my bedroom because my dogs are barking and my next door neighbor's baby's crying. So this is a chair in my room. You don't know that. That's how amazing technology is. I could be wearing pajamas, from the bottom down. And you don't know if I've showered in a week. But what I'm telling you is that this is how we can deal with things. So if you've got a client who's desperate to view a property, you know, you can say to him, I'll set up a Zoom meeting with you, with the current tenant or the current owner. Let's do a viewing. And you can do a virtual viewing with your clients on your mobile devices or on your PC. And not that I would say would you know, meet the tick boxes of an ingoing inspection or you know, properly inspecting the property for purchase for the purpose of any sort of defect in the property, but at least gets the ball rolling. And you know, parties are everyone is sitting at home, so it's the perfect time to go out there and punt and say, we're doing virtual viewings of property, or email us for a virtual viewing and contact your current tenants or occupants and say, are you willing to do this with me? Are you willing to help me? I'll help you in some way, you know, and just really start negotiating and working with each other. Everyone is willing to help each other at the moment. And I think it's a very cool space to be in, to be able to say, you know, our agency is offering virtual viewings, and your tenant will just be walking around the property with the phone, and you'll be leading the viewing and showing them everything, you know, what the property looked like. This is where the kitchen is, this is this, this is this, pointing out defects as you go along, and being open and honest, and like Anastasia said before, like knowing exactly what you are entering into, and knowing what duties and obligations and risks you're taking during this time, but also using our technology, using what we've got, and not, you know, just hoping for the lockdown to pass, but using the time that we have. We have so much time. It's time to be creative and to get out there and to make the best of the situation, I'd say. So that I would use Zoom for that, or any other sort of platform, but no, not for electronic signatures, but maybe just meeting some of the tick boxes in terms of your actual agreement to get things done in the interim. I think it's a good idea.
Thanks, Liezl, for that. Guys, I think we've gone through our slide and all the parts of our slide. I think the last slide there is concluding remarks. Liezl, do you have any? Unless there are any other questions, but remember, guys, part 3 of our series of talks, it's going to be an open forum for Q&A sessions. So if we haven't answered any of your questions today, or if you haven't asked any questions today, please feel free. Just chat to Vanessa. She'll keep you informed of the date and when that'll happen. But it's going to be an open forum. And some of our other colleagues will join us as well. So you'll have a team of attorneys who will hopefully answer all of your questions. Any concluding remarks, Liezl?
No, last thing I wanted to say is just on loan approvals that have been granted, is just from like our agent clients and mortgage originators perspective, is just to have a chat with purchasers in just regarding the loan approvals, and if their situations have changed, just to like hold their hand and assist them in this time, if they have anything that they need to discuss. But other than that, I think we've touched on the most important aspects and how we can deal with things during the lockdown. And yeah, next week we'll cover lease agreements, which is a whole different animal. So if you guys have any questions on offers still now, David and I and Anastasia and Vanessa and Pamela and whoever else is here, we're going to hang around a bit still. So if you need to leave the meeting, you're more than welcome to.
Just unmute Anastasia, Liezl.
I think I have. I think she muted herself.
Oh. There was also a question from Tracy, I think, earlier before we started. She wanted 2 minutes afterwards. So yeah, we're here.
Okay.
Anastasia?
I just want to say I'm so sorry. I didn't realize that everybody could see my husband eating cheese while we're doing this. I'm sorry about that. But I didn't know that I'm still on there. And that's so. It's what you were saying, Liezl, about how we can use technology. You know, it is so amazing, and the world is changing for us, and it gives us so many opportunities. But it also teaches us we need to be really, really careful and get used to our new normal very, very quickly. We can make a few boo-boos like I've just done. So sorry about that.
Excellent, no problem. Liezl, can you unmute Chrissy H?
Yes, I'm going to do that now. Also, I'm going to...
But yeah, I'll obviously keep you posted. I'll send the notes out to everyone, and I'll let you know when the next session will be held.
Great. Yeah, thanks very much, Vanessa, for facilitating this for us, and to Carl and to Anastasia for allowing us to talk to all of your lovely clients in Johannesburg. So guys, just from my side in closing, I would just like to once again say thank you very much for joining us. And in summary, business as usual, as far as possible, guys. You can still take your deals, you can still do business, albeit on a slightly different way, but please, guys, we're here to assist you and do business as much as you can. So thanks, and hopefully see all of you next week.
Thank you. Goodbye, everybody.
Bye, everyone.